Hello, good morning. We're just going to give everyone a moment to get in before we start the webinar. If you are looking for a copy of the deck, you can find a link in the chat, so you can go ahead and download the slides if you would like to have those. I still see the attendees are coming in, so we'll give it a few more seconds and then we'll begin because we have a lot to cover today. All right, I think I'm going to get going. So good morning or good afternoon, depending on what part of the country you are in. Welcome to CFIB's Maximizing Your Webinar, or Maximizing Your Membership webinar. This one is called Legal Peace of Mind, How Employment Contracts Protect Your Business. And we have a very special guest today, our new legal partner, LawVo. So happy New Year. Welcome to our first webinar of the year. Before we begin, I'm going to go over a few housekeeping items. Below, there are two methods of communication with us. There is the chat, which is where you can communicate with other webinar guests. And then there is the Q&A, and this is where you can post your questions to our team, and some of them are going to be answered back by chat, and then some of them we may save and answer them live during the course of the webinar. As you can see from in the chat, we've actually added a link to the slides for you to download. And also everyone who has registered, whether they're watching it live or whether they watch the recording, will get a copy of the recording and the deck in an email sometime tomorrow. So I'm Jocelyn. For those of you who don't know me, I'm Jocelyn Reinders. I'm the Senior Manager of Business Resources Initiatives in Moncton, New Brunswick, and I'm joined today by Lena Vartanian. She is the Chief Operations Officer and co-founder of LawVo, and she's going to be joining us in a few minutes. We also have several CFIB and LawVo folks in the background here to answer questions, as I mentioned, that might be coming up in the webinar. So this is a great time to ask you, where are all of you from? Please say hello and type where you are joining us from right there in the chat. Let's see who we have. Toronto, Hampton, Windsor, Allison, Guelph, Cornwall, Kitchen, Winnipeg. Hello. Oh gosh, they're going so fast. Montreal, Sudbury, Barrie, Winnipeg, Calgary, Nova Scotia, St. John, New Brunswick. This is one of the best things about CFIB. We're all in this together. We are all here to make sure all of your small businesses have the best chances of success. So this is exciting. CBCs, PEI, Newfoundland, Lincoln, Ontario, Manitoba. Welcome everyone. Today we have a lot of information to cover, and then we're going to take a look at the next slide, which is our agenda. We are going to be touching on CFIB's new partnership. Magda, if we could go to the next one, we're going to talk about CFIB and LawVo's new partnership. And we are going to then have Lena come and present about employment contracts. Then we're going to actually talk about some solutions that you can use about any employment contracts concern that might come up during the webinar. And finally, as always, we will have our Q&A. And that's perfect. Thank you. So I've actually been with CFIB Business Resources for over 14 years. And one of the things that we've always wanted was we wanted to be able to provide legal advice and support for our members. And we are so pleased to announce that we now have the ability to do that through LawVo. Some of you may have already heard, but we did a soft launch with LawVo back in November, and some of our members have already had the opportunity to use their services. And LawVo is providing CFIB business resources with tools to provide legal information directly to our members. And it's a variety of legal topics that are important to you, everything from employment and human rights, health and safety, workers' compensation, landlord, tenant, commercial lease questions, taxation questions, even immigration, and so much more. So next, you may be wondering how, as a member, you can access LawVo's services. So there's 3 pathways, and the first step to all of them is to contact business advisors through HR Now by calling or emailing us. So from then, when you call us or when you contact us, we're going to determine which one of LawVo's services are best to meet your needs. Sometimes your question simply needs a little bit of legal information, which we can give you directly using LawVo's tools. This kind of information, it's not a legal opinion, it's not a recommendation, and business advisors can give you that information directly. However, if you do need a legal opinion or a recommendation, that's when a business advisor can submit a request to have a LawVo lawyer call you through their telephone legal advice line. And when you work with a TLA lawyer, that's where you can discuss your questions or issues with that lawyer, and it is included in your membership. And sometimes, though, however, you're going to need a little bit more than a recommendation or an opinion. And sometimes you need a lawyer to do some work for you. And this would be something like drafting documents or reviewing larger contracts, and sometimes even go to court on your behalf. So if that's the case, what we would do is set up a meet and greet call with a lawyer who's often a local law firm. And that's where you can actually discuss your situation, the options, what kind of work the lawyer would actually do for you, and what the cost would be. If you choose to hire that lawyer, you get 25% off whatever the regular fees are. So that is a huge discount that we're very happy to pass on. And as mentioned, next, we've had access to LawVo's service since November. So we wanted to look at what are you calling us consistently about? And the top inquiry from members so far has been termination entitlements. Okay, so maybe you're thinking, what does termination entitlements have to do with employment contracts? It actually is quite a bit to do with termination entitlements. And as Lena will cover, one of the top determinants of how much you owe an employee upon termination of employment actually depends on the contract that you set up at the beginning of the employment relationship. And seeing as this is one of the most important tools in protecting your business, we thought that maybe this would be a great opportunity to introduce all of you to LawVo through a webinar. So before we introduce Lena, we have a little bit of a poll for you. So you're going to see on the screen a question, and please feel free to answer it. The question is, how frequently do you update your employment contracts? So maybe you don't have any employment contracts. That's okay. We're going to help you out. We do have written employment contracts upon hiring, but we generally don't update them. We update our contracts when an employee gets a promotion or a significant raise, or we regularly review for updates to terms and conditions. So we're just going to give that a little bit of a minute, and we'll see what the consensus is before we move on. And I don't know when you guys can see some answers, if you want to share them. Do we have the answers to the poll? Ah, yes, that's great. 50% of you do have a written contract upon hiring, but you generally don't update them. that is perfectly okay. There are some really good reasons, and Lena's going to go over them as to why you may want to review those contracts and why you might want to consider updating them. And 21% of you don't have employment contracts. That's okay too. That's something that we're actually going to offer you as part of this webinar. And 18% of you are updating them whenever you employees get a promotion or raise, which is great. And 12% of you are regularly reviewing them for updated terms and conditions. So this is great. We can see everybody is in a different place. And this is a perfect opportunity to bring Lena up and have her share her information with us. So welcome, Lena, to our CFIB webinar.
Good morning, good afternoon. Again, depending where you are. Thank you so much for that introduction, Jocelyn. And I already see some questions here. There's one from Jason, interested to know what termination entitlements are required when there is no contract in place. We will be answering your question and many, many more. So again, thank you, Jocelyn, for that wonderful introduction. We're so happy to have the CFIB as one of our partners and to have been working with CFIB as well as the members since November. And we're really, really excited to continue to provide access to legal services to the CFIB members. So again, thank you everyone for being here and joining us today. I'm really excited about the information that I'll be providing. Just a disclaimer, all of this is legal information. Of course, you know, legal advice is an individual thing. So please do contact the CFIB to connect you with our services. So welcome to Introduction to Employment Contracts. Although, as I understand, most of you are business owners, I think fortunately, or maybe unfortunately, you may have learned a thing or two about the importance of employment contracts. What I'm really going to focus on, as Jocelyn mentioned, is on the enforceability and voidability, and that really revolves around the termination clauses that you have in your employment contract. So before we delve into the employment contract, I'm just going to speak very briefly about the legislations that impact employment agreements. So the first one is the Provincial and Territorial Employment Standards Acts, the Provincial and Territorial Human Rights Codes, acts in relations to accessibility for disabilities, occupational health and safety codes, as well as the common law, which is essentially judge-made decisions, and we will talk about that a little bit more in detail. So moving on to the next slide. Just very briefly, the Employment Standards Act is essential in that it provides the employer with a guideline in terms of payment of wages. So things like, you know, the minimum wage in a particular province, as well as things like a summary of, you know, payments and ensuring that payments are paid on a regular basis. Also prescribes the hours of work and overtime. So the, you know, maximum hours of work that employee may work, over which and above the employer may have to pay overtime. It also prescribes things like leave of absences, which would relate to things like maternity leave, parental leave, also things like critical illness or entitlements to family related illnesses. Also termination and severance, which will be the focus of our presentation today, as well as other things like record keeping, you know, ensuring that you have up-to-date records that are maintained for a specific amount of time in accordance with whatever governmental legislations would apply to your business, and also vacation time and pay. So really, in Ontario, you know, the most significant portion of the Employment Standards Act, what we'll be talking about today, is the termination provisions. And there's actually regulation to the Employment Standards Act, which provides a threshold by which an employer may terminate an employee for cause. And in Ontario, the relevant section is 2 sub 1 sub 3, which states that an employee may be terminated for cause if they've been guilty of willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. This this provision has been interpreted by the courts, and we could probably spend about the next 5 to 10 days just talking about the decisions that have interpreted this, but it is a fairly high threshold. But what to kind of take away here is that any employment contract that you have must comply with the Employment Standards Act at a minimum, otherwise it will be deemed to be unenforceable. So moving on to the next slide. The various provinces and territories have their own human rights codes, and they provide for protection to employees on various protected grounds. So, just right on the screen, race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, age, record of offenses, marital status, family status, or disability. So the important takeaway for employers is that these grounds are protected. However, there's something that an employer has to ensure throughout the employment process. So even, from hiring, there's certain things that you can ask, that you cannot ask. So to ensure that in the process of hiring, as well as throughout the employment, and also in the process of termination, to ensure that you are complying with the Human Rights Code, because failure to comply with the Human Rights Code could actually expose you to additional damages, in addition to bad faith allegations. Why are employment contracts important? So it's imperative that employment contracts are implemented for several reasons. Essentially, they would clarify the terms and the relationship of the employee and the employer so that there's no misunderstandings in the future with regard to job expectations or job performance standards. Employment contracts also provide legal protections, and that would generally be, balance between the more towards the employer. However, they also offer some protections to employees. And especially for employers with regard to employment contracts, it's really important to have them because you could avoid claims for wrongful dismissal or other legal actions. Employment contracts are also important, again, for termination clauses because you can actually limit what you're willing to pay an employee when you do terminate them for cause or without cause. So to go back to Jason's question, if you don't have an employment contract and you don't have a termination clause, then you would be likely on the hook for common law damages. So under the ESA, generally it's about a week per year of service. Don't quote me on that, but I believe that's the general minimum. Under the common law, you could be liable for up to 1 month reasonable notice or pay in lieu of notice for termination of an employee without cause. So it's really important that you do have an employment contract and that you have a valid termination clause within. And it's also important that you will see that later on in the cases that we discussed, that both the termination with cause and termination without cause provisions must be valid in order for the complete employment contract to be upheld by the court. Another reason why you may want to have an employment contract is confidentiality. So given the nature of the business, there may be certain proprietary information that the employees exposed to. So for an employer to protect their proprietary interests and their business interests, they may want to include things like a non-compete or a non-solicitation or confidentiality clause.
Hi, Letta. Um, the next, I know you're about to talk about what it is to have like an oral agreement versus a written agreement. And there's been a lot of questions about whether or not an agreement such as an employee handbook with all of the details of employment could be considered as some kind of a contract. And we also have a question about whether or not an email with all of the details that would normally be in a contract could also be served as an employment contract. So seeing as they fit with this piece of information, I just thought I would put those out there for you.
Perfect. So to answer those questions, in order for you to have a valid employment contract, the terms of the employment contract must be reviewed by the employee, and they also must be agreed to. There must also be, very importantly, consideration for the employee to accept those terms. So consideration is, just to give you like a brief understanding of what it is, for any contract to be valid in Ontario or in Canada or in the world for that matter, there must be a consideration. So a promise to pay, it may be monetary, or it may be a promise to do or not to do something, much like Shakespeare. So if an email is sent, that would likely not be upheld as an employment contract unless, there was an exchange of monetary consideration or some other type of consideration. In addition, the employee must agree to the terms. That the same rule would apply, I would say, to a handbook, laying out the information in the handbook. Unless there's provision that the employee sign the handbook and that becomes part of the employment agreement, then it likely would not be upheld. Fernand, is there anything?
Yeah. Hi, everyone. It's Fernand Vartana from the LawVo team as well. And just echoing what Lena did mention. So again, an email is very difficult because you typically do not have some form of a signature. And it's very difficult to prove that that has been received or anything of that nature. You always want some kind of an electronic signature or a wedding signature on a contract for it to be valid. And in terms of just echoing what Lena said, in terms of the handbook, a handbook again, it typically is embedded into an employment agreement, but in and of itself is not sufficient to count as an employment contract. So it's always better to have a contract signed wet ink or by electronic signature for it to be upheld by a court.
So moving on to consequences of not having employment agreements. I won't spend too much time here. These slides will be available to you, but essentially you have what we've kind of just discussed, an increased risk of disputes, legal uncertainties. So again, if you don't have a contract, the common law reasonable notice would apply rather than the minimum requirements under the Employment Standards Act. Also, a lack of protection for employers, so things like confidentiality and intellectual property, non-compete clauses, and the like. Cost of termination. There's a significant difference between 1 week notice or 1 month, or in some cases 1 year. Also, it may be unclear in terms of what the expectations are and performance standards. So without outlining these types of things in an employment agreement, it's really hard to kind of go back and say, well, you're not living up to the standards that we had, the performance standards that we had expected from you, without having, something to reference and go back to. So going on to the next slide. Employer obligations and responsibilities upon termination. So, it's common knowledge that whenever you do terminate an employee, they are entitled to reasonable notice or pay in lieu of the reasonable notice. Now, again, the Employment Standards Act would prescribe certain minimum requirements. However, employment contracts may limit that, as long as it complies with that. In the absence of a employment contract, you may be liable for common law notice. Severance pay, again, this is prescribed under the Employment Standards Act. Employers with a payroll of 2.5 million or more, or those who terminate 50 or more employees within a 6-month period due to a business closure, must provide severance pay to employees with 5 or more years of service. Final payments, employers must ensure that all outstanding wages, other things like expenses, vacation pay, and other entitlements are paid to the employee promptly upon termination. Also, to ensure that you issue a record of employment in accordance with the guidelines. This is one really, really important thing that maybe a lot of employers don't know, is that if you are providing benefits to your employees, you must continue to provide those benefits throughout the process of the reasonable notice, while you're paying the reasonable notice. Because if you do not, you may be, again, liable for breaching the Employment Standards Act. So do ensure that you are paying your benefits throughout the reasonable notice period. Okay, and again, just to come back to employers ensuring that termination is in accordance with all the human rights codes that are in place as well. Things that may invalidate, so this is, we're really getting into the heart of it now. Things that would invalidate employment contracts. So recent court cases have highlighted several reasons why a court may hold an employment contract unenforceable. So we'll just briefly talk about some things, some considerations, and then I will be talking about 2 cases that have highlighted this, and just to give you an understanding of the way the courts analyze the contracts and the decisions that they came to. So the first is a lack of consideration for contracts. So that goes back to, again, you have to ensure that you have consideration for the contract. And also, it's really important that the employee signs the employment contract before they commence employment, and on the terms that were discussed and agreed to at the time when an offer letter or employment was discussed. Another reason is unclear or ambiguous terms, non-compliance with the Employment Standards Act minimums, failure to complain terms, inequality in bargaining powers, and non-compete terms. So I'll explain all of these a little bit more in detail, but just in terms of inequality in bargaining powers, it's generally assumed by the courts that the employer is the one that is the more sophisticated individual in the negotiation of the contract. So generally, the courts will tend to interpret a contract against the more sophisticated parties, so more in favor of employees. And also, we'll talk a little bit more about non-compete terms. So moving to the next slide. So our first case is Holland and Hostopia. So in this case, Mr. Holland was given an offer of employment by Hostopia Inc. And the offer contained a statement that he would agree to sign an employment contract at a later date. The same day that he signed the offer letter, he also agreed to a proprietary services agreement, which provided that he would not compete for a 6-month period, and also that he would not solicit current clients of Hostopia for a 1-year period. So he signs an employment contract 9 months later. Unbeknownst to him, generally, employees will just sign whatever contract they're presented with. The employer had actually changed the terms of the employment contract to not reflect what they had initially agreed to. Also of great importance, just going back, is that the offer letter did not contain mention of a termination clause. So based on an offer letter that does not contain a termination clause, this is also really important. It's assumed that the common law reasonable notice would apply to an employment contract as well. So that's also a really important takeaway from this case. So he signs the employment agreement. Unbeknownst to him, there is a termination provision contained within the employment agreement, and it is the minimum requirements under the Employment Standard Act. So it's, essentially weeks notice. And so now the employers changed the termination provision, and they've also doubled the non-compete provision as well as the solicitation provision. So Mr. Holland was terminated without cause after 7 years, and he was provided with the minimum notice requirements according to his employment contract. So he brings an action for wrongful dismissal against his employer. The Court of Appeal held that the termination clause was unenforceable because the offer letter did not contain an express provision for termination. As such, Mr. Holland should be entitled to common law notice of termination. In addition, he had signed the agreement 9 months after he had commenced employment, and there was no consideration for the changes in the employment contract. There was also no evidence that the court found that Mr. Holland had been advised or that it was negotiated with him. So the implication here is the case underscores the importance of ensuring that any employment contract, particularly those containing termination provisions, are signed before the employee begins work. And if there is an offer letter, to ensure that the termination provision is also contained within the offer letter. Now, if you do have, employment contracts, and now you're thinking, perhaps I want to change something, well, a good time to do that would generally be because keeping in mind that you need fresh consideration for any changes to employment contracts. If an employee is now working, in a regular capacity and you're thinking of promoting them to manager, you could then change the terms of the employment agreement. They're being paid more. However, of course, as with any other contract, the employee would have to be apprised of any changes within the employment contract.
So great timing to sneak in a little question, Lena, if you don't mind. So when you're talking about the contracts, if members have a long-term employee and you're talking about considerations, consideration being something that is given to them for the signing. Would this be the process that they would use at this point? So employee's been with them 20 years, they never had a contract, they want to bring in a contract now. So is that the enticement, is the consideration?
Exactly. So it would have to be, some type of consideration, whether it's monetary, whether it is, to do something or not to do something, as long as there's some type of consideration. Again, just basic contract law, there must be a meeting of the minds. Both parties have to agree to the terms. And as long as you have fresh consideration, the contract is signed and agreed to, then yes, definitely.
Perfect.
So
Thank you.
there was an example we can share as well. In addition to giving, I guess, a promotion and increase in salary, fresh consideration can also include a bonus. So if you paid the employee a bonus for, and then that can count as consideration to change the terms of the contract as well. And typically, just I think a couple of slides back, I want to reiterate, because of the bargaining power discrepancy, the contract should always have clauses in there that the employee has had an opportunity and has been encouraged to seek legal counsel prior to signing. So you typically give them some time to digest the contract and get legal representation if they choose to do so before they sign the contract. So you never want to pressure them into signing something. Always give them the opportunity to have it reviewed. And like I said, the templates that will be provided through the CFIB, it does have that particular clause in there for your benefit.
Thanks, Vernon. So the Waxdale decision is a significant case concerning the enforceability of termination provisions, and this is a decision that came out of the Ontario Court of Appeal. Again, just to highlight, termination provisions must meet the Minimum Employment Standard Act provisions. However, what happens when a termination clause almost meets the minimum requirement? So this is what the Waxdale decision is about. Mr. Waxdale began his employment with Swagon North America in the role of Director of Sales. After approximately 8 months of working for Swagon, they terminated Mr. Waxdale for without cause. So they paid him 2 weeks' salary in lieu of notice as required under his employment contract. So he did have an employment contract that he executed, and the employment contract had a termination with cause provision as well as a termination without cause. So terminated without cause in accordance with the terms of his employment contract, which for all intents and purposes was valid as it was compliant with the minimum employment standard. However, it was conceded by the defendants, which were Swagon in this case, that the termination for cause provision actually did not comply with the Employment Standards Act and that it was void. So what they tried to argue, the employer tried to argue was, well, we're not relying on the termination for cause provision. We're only relying on the termination without cause provision. And that's what we terminated him in accordance with, and it is a valid provision. So the whole employment contract should remain. It should be enforceable. The court decided, well, the court held that that was not the case. And in their analysis, the Ontario Court of Appeal held that employment agreements must be read as a whole, not in a piecemeal fashion. So if one provision in the employment contract regarding termination is void, then the complete employment contract is void. So in this case, Mr. Waxdale was entitled to common law reasonable notice, a situation which Swagon, I'm sure, had hoped to avoid. So the takeaway for employers is that Waxdale has essentially fundamentally altered the enforceability of a without cause termination provision paired with an enforceable without cause termination provision with an unenforceable with cause termination provision. So going forward, it's really important that every element of an employment contract relating to termination must comply with the minimum ESA standards, or the Employment Standard Act.
Hi, Lena. Sunny just asked that for the Waxdale case, it's not really clear, what did the employer do wrong in that situation? What could the employer have done to avoid that situation?
Yes, so it's not that the employer did anything wrong. It was, I guess, that Mr. Waxdale had likely a really good lawyer friend that he spoke to and said, listen, this is what they paid me. Have a look at my contract. And the contract actually was not, they made an argument that the contract shouldn't be enforceable because, both termination provisions are not consistent.
So Jocelyn, just to add to Lena's point, she's right. Swagon didn't do anything wrong. The decision, in essence, invalidated over 90% of employment contracts in Ontario. And sometimes, like I said, bad facts create bad law. What does that mean? Someone, like an employee, comes with, a narrative to the court that the court feels, really sort of elicits a response from the court, and the court will really dig into the contract to make sure that all the T's were crossed and the I's were dotted. So Swagon, and along with 90% of all employers that had employment contracts, this decision invalidated it. That's why, like I said, as lawyers, we try to draft contracts, employment contracts, with a fine-tooth comb, but law changes, especially judge-made law changes, and that's why it's important to have your contracts reviewed regularly, because these types of decisions come down. Now, if you want to get into the particulars in terms of, getting a little bit legalistic in terms of what happened here, is, if you remember, Lena talked about the ESA mentioned willful misconduct, which is a higher threshold than cause termination. And because that contract didn't sort of address the difference between willful misconduct and cause under common law, the court basically threw out the contract. So you can see a minor discrepancy like that gave the court that window to really come in and decide on behalf of the employee.
Thank you both. So I just want to mention we have about 15 minutes left. We have tons of questions, and we're just about to kind of wrap up with some good solutions and things. So I think a lot of the questions will be answered in the next few slides, and then we'll open it up to Q&A. Thank you, guys.
Perfect. Thank you so much. I'm just going to briefly talk. I saw something in the chat about severability. That's a really good point. So generally in contracts, whenever there is something that's called an impugn provision, the courts will generally say, no, we can actually remove this provision from the contract and the whole contract will remain intact. Unfortunately, after the Waxdale decision, it's very clear that any inconsistent terms regarding termination cannot be severed. The contract as a whole will be held to be unenforceable. So just moving along very quickly, I'll run through this, and I like that the logo is very similar to running. Non-competition clauses. So as of October 25th, 2021, under the ESA, any agreements between employees and employers that limit their rights to engage in business or activity in competition with their current or former employer's business after the employment relationship has ended are prohibited. Any non-compete agreements which were agreed to before October 25, 2021, subject to review for reasonableness, may still be enforceable. There's exceptions that may apply, things like, if if a party sells their company to another party, and then they may go work for the purchaser. So in those situations, it may apply. And also if an employee is listed as a senior level executive employee. Non-solicitation and non-disclosure agreements are not prohibited. And then just coming to our second last slide, we're almost there. Clauses can't be one-sided. So also in terms of termination provisions, things like, I can terminate you at my sole discretion or at any time will generally be found to be unenforceable. Again, keeping in mind Minimum Employment Standard Act provisions. So the solution, mitigating the risk of exposure, ensure that you comply with the minimum standards of the Employment Contract Minimum Standards Act, ensure you have employment contracts, comply with your good faith obligations, also keeping in mind human rights and all other applicable legislations to ensure that you also have an employment valid contract which an employee signs at inception and for which they have sufficient consideration. Best practices, ensure that you regularly consult with a legal professional to review your contracts, at least on a biannual basis, as the case law in this area can change significantly and consequences could be significant. Third, CFIB, contact LawVo, call our legal helpline. It's available 24/7. Thank you everyone for your attention. I hope that the presentation was helpful.
Yeah. So next up, we actually have a little bit of a flow chart for everyone. And this is going to be really important because, as mentioned, it will answer a lot of your questions. So first up is if you have an employment contract already in existence and it is less than 6 pages or less, and you want us, LawVo, to review the contract, give us a call in BR and we're going to connect you with a LawVo lawyer, and they will review your contract with you. And so this is a review. You can ask questions, but they're not going to customize the document for you. A lawyer can't rewrite the document for you, but they may point out where there's maybe some red flags or some things that you want to change. This is not at any additional charge to your membership, so we can promise that for you. If you do have an employee contract, but it's longer than 6 pages, give us a call. That is going to require some representation because that's when the lawyer needs to actually do a little bit of work. It's more involved. And that way, the referral lawyer will review the contract. You decide the level of customation and review to be completed. And there will be fees like you would pay a regular lawyer, but it's at 25% of their regular discount. Again, if you don't have an employee contract, but you're thinking, oh my gosh, I better get one, give us a call and we're going to give you a copy of the contract. In fact, everyone who's at the webinar is getting a copy of LawVo's employment contract. And you can either use it as it is, you can fill it out, and that's good for straightforward employment positions. You can customize it yourself, which we don't recommend, but you can always do that, of course. Or you can give us a call. You can customize it with a LawVo lawyer through their representation program. And of course, as above, the legal fees will apply. And finally, if you want a customized contract, that can be done as well. So there's lots of different options here. I think it's important to know that everyone is going to get a copy of a brand new up-to-date LawVo employment contract. So hopefully that will help with some of the questions, but there was some great questions. One that I saw multiple times was, is there a difference between an employment contract and a letter of offer, or are those just interchangeable terms?
Yeah, it's a great question. Elena, did you want to take that?
You can go ahead. That's fine.
Okay. So an offer is exactly what that is. It's there to be accepted, but you typically have to, and it's usually verbal, you typically have to sort of take that contents and put it into an actual employment contract and have it signed. So there's always the difference between offer and an actual contract. So they're not the same. And we would always recommend not relying on just an offer, but actually doing an actual contract itself. And contracts, employment contracts, are actually called an offer of employment, but it becomes a contract when you sign it.
Okay, excellent.
Just to add to what Fern was saying, keeping in mind what I was discussing before, if you would like to have a termination provision, ensure that it is contained within the offer letter, because the employment contract must be consistent with the terms that are agreed to in the offer letter. So they're two different things, but they should reach the same result.
Mm-hmm. Great. I also saw a series of questions regarding seasonal employees. So the question is that if you have an employee that works for you for, let's say, 6 months, they sign at the beginning of the season, how does that work? If they rehire, do they need a brand new contract that the following season, or does it carry over? That's part of, I guess that's the first part of the question. And the second part is, do you need to provide termination notice or pay in lieu for seasonal workers?
Yeah, that's a great question. So typically, if they're seasonal, sometimes it's recommended that they become independent contractors rather than employees, and they work on a contract basis for 6 months. And so that's one solution. Again, in your particular circumstances, obviously call the helpline and they can advise you. But typically, what happens in those situations that we've seen and what we've recommended based on the facts is that you would have a contract, a fixed term contract for 6 months. So you wouldn't necessarily be an employee. You'd be a contractor, an employee on a contract for a fixed term, which would potentially, I say, negate your termination provisions, because we've also seen cases where independent contractors have been found to be employees by the courts. But if you're trying to mitigate it, enter into an independent contractor agreement is what we would probably advise.
With a lawyer's support.
With a lawyer supporting, absolutely.
Absolutely. Yeah. Here's a question. I love this one. What if you present a contract with consideration and an employee refuses to sign it?
Okay, and I guess the follow-up question to that would be, do you really want that employee, or is it a take it or leave it? Because if it's a take it or leave it, if they don't accept it, then the offer is rescinded. So if you give them 7 days, for example, 5 to 7 days to sign it, and they don't, then the offer is rescinded. They can't actually accept it. And if they want more, then it becomes a fresh negotiation, right? But if it's not accepted, as I said, then the offer is rescinded.
There is so many great questions. We still have some time. One of the questions I thought was really good was about actually reducing hours, which I think brings up something, called constructive dismissal, which some of our members may not be aware of. Do you guys just want to cover that in short to explain why you might not want to do something like that with a sharp line?
Absolutely. So that's also another topic that can take hours to discuss. But shortly, briefly, constructive dismissal for everyone is when either hours are reduced, or someone is demoted, or someone is given less salary. So if they started at 50,000, but then you said they're only going to get 30,000, then that can be deemed to be constructive dismissal. Including a reduction in hours. It can be found to be constructive dismissal, which basically that means then that the employee can in essence quit and then sue you for wrongful dismissal, and then you would owe them for various notice provisions. Now you can talk to a lawyer in terms of how to address that. Typically, to avoid that, what you'd have to potentially do is it's complex. I won't get into it, but there's ways of addressing it. So if you want to change aspects of an employee's job, whether it's their title or whether it's their salary or whether it's their any fundamental aspect of their business, there's ways of doing it. Contact a lawyer. But for the purposes of this call, on its face, it's a constructive dismissal, which may lead to a wrongful dismissal claim against you.
I'm going to pop in with another one and maybe put LawVo on the spot, maybe, but I don't think so.
All right.
Contracting outside the law. So we've seen a lot of questions about, my employee is willing to do this for less overtime pay, or, I could, provide a contract that might not be up to employment standard rules. Can we talk a little bit about contracting outside the law on that side?
Absolutely. So you can contract out of common law, but you cannot contract out of the ESA. Never. You can never contract out of the Human Rights Code. You can never contract out of occupational health and safety. You can never contract out of those types of statutes. The only thing that you can contract out of is the common law, which employers always do, because not always, they try to do, because the common law obligations and notice are just so severe, right? For example, we've seen cases where people get up to 24 months notice in Ontario and other provinces, Alberta, BC, and it's gone up to 27 months notice in Quebec under common law. So you can see why it's so imperative to try and contract out of common law by having proper employment agreements.
Thanks.
See, I think I was able to answer that, Danielle.
Yes, good job.
Yeah.
Thank you.
Absolutely.
And one more, if I can, because we have a few more minutes. There's more questions about making changes. So we've talked about the employee contract, we've talked about the letter of offer, we've even talked about the employee handbook. Now, if you're making changes to one of those, should you be doing this as a whole? Because Lena, I believe you talked about the importance of all of these tying in together. But what if you're just making a change to an employee handbook? How is that going to impact your letter of offer? Or what kind of red flags should we be looking at?
Yeah, so employee handbooks typically would have the workplace policies. That's the assumption I'm taking. So I have workplace policies in terms of dress code or anti-bullying and things of that nature. So in your offer letter, you typically can have a clause in there that those can be changed from time to time with notice. That doesn't require fresh consideration for that. But what does require fresh consideration is terms, material terms, i.e., if you're trying to limit their rights under common law, for example, if you never did that before, or anything in relation to that. But in terms of workplace policies, we typically have clauses in the contract that allow us the flexibility for you to make changes from time to time with notice.
Perfect. Well, I just noticed what time it is. So we have just a reminder for everyone that we're going to send a copy of the recording, the deck, and the LawVo employment contract. And really, really want to thank LawVo. Obviously, there's a lot of questions we didn't get to. We're going to try to pull together a resource and present that to everyone that has registered for the webinar. Thank you so much, Lena. Thank you so much, Fernand. This is, a very, very exciting time for CFIB and all of our members to have your support. And so we really appreciate that. Just a reminder, we do have a webinar coming up next month. I know you guys are very interested to know what the heck is happening in Ottawa. So that's going to be coming up in February. So please join us, and we will have some webinars coming up again in March. I probably wish we had a whole nother hour to answer questions, but thank you, Lena. Thank you, Fernand. I'm sure we'll be seeing more of you. And thank you, everyone, for joining us. And we will now end the webinar.
Thank you.
Thank you, everyone. Thank you. Thanks, Jocelyn.